Well, so we're very lucky to have Mariana Pargendler from FGV Law School in Sao Paulo, and Mariana writes on topics of corporate governance, often with a comparative perspective. But I'll just to sort of whet everybody's appetite, say I'm really looking forward to this conversation because it occurred to me as I was reading this paper that it's one of those papers that's just perfectly suited for this type of all faculty audience, in that it really lies at the intersection of many different areas of law. So I expect lots of people will see something in it that that seems really relevant to their research interests. So I'll, with that, let the presenter start presenting, and I will keep a queue. So our idea is that Mariana will present the paper with plenty of time left over for questions. So if you have a question, raise your Zoom hand. I'll rely on the hand raising function to keep the queue for questions. If you write something in the chat, I can't promise that I'll see it. So with that, I'll turn things over.
Thank you so much for the opportunity to present my work. So I will share this presentation with you. This is a paper about the theory of corporate personality, which is a very old topic. And I claim here that I have something new and useful to say, and that hopes to be useful not only for corporate law scholars, as Abe said, but also for various areas of the law. So first, I will tell you about the state of the law and economics literature on the role of corporate personality. So according to this literature, the main role of corporate personality is asset partitioning, which is the separation of the assets of the firm from those of its shareholders. There are also various exceptions to asset partitioning, of which the most prominent is veil piercing, which means holding shareholders liable for corporate obligations. That is great, I think. That's very important. I do not want to deny the importance of asset partitioning, but in this paper, I want to highlight another function of corporate personality, which I call regulatory partitioning, meaning that the corporation will be separate from its shareholders for purposes of the imputation of legal rights and duties beyond the attribution of patrimony or assets. I will also suggest that regulatory partitioning is also subject to exceptions, and I coined the term for exceptions to regulatory partitioning, which is veil peeking, as opposed to veil piercing as an exception to asset partitioning. So to illustrate, you suppose you have Alice who buys a few shares of Apple Inc., a publicly traded company. Suppose Alice is French, she's Black, she's bound by a certain non-compete agreement applicable to the technology industry, and she did something wrong and is debarred from contracting with the US government. Regulatory partitioning means that Apple is not French, is not Black, is not bound by the non-compete agreement, and is not debarred from contracting with the US government, meaning Apple is separate from Alice in various ways beyond the separation between Alice's assets and Apple's assets. The important point here, however, is that if Alice were not a minority shareholder of Apple, but a controlling shareholder of Apple, the law would sometimes create exceptions to regulatory partitioning, so as to attribute Alice's nationality, race, contractual obligations, and sanctions to a company controlled by Alice. So here are the main claims of this paper. The first one, as I mentioned before, which is that corporate personality also provides for regulatory partitioning in addition to asset partitioning. This is an important role of corporate personality. I would like to suggest that many corporations existing in the real world are formed for reasons of regulatory partitioning rather than asset partitioning. And here I have in mind the hundreds or perhaps even thousands of subsidiaries of large corporations. Some of them might be formed for asset partitioning, but we know that cross guarantees, which undo asset partitioning, are quite common in corporate groups. So one very plausible reason for many existing subsidiaries is regulatory partitioning, especially in the form of tax or other regulatory benefits. Second claim is that regulatory partitioning entails distinct benefits and costs, distinct from those of asset partitioning. Third claim is that veil peaking, which is regulatory departitioning, is pervasive across areas of law. It is not rare at all. Rather, it is quite common, probably more common than veil piercing as an exception to limited liability. And as a corollary, the normative takeaway is that veil piercing and veil peaking, because they are analytically and functionally distinct, they should be subject to different criteria, and in particular, the restrictive criteria applicable to veil piercing, such as fraud or commingling of assets, should not apply to veil peaking claims. Here I have one traditional, quite prevalent view of the corporation as a nexus of contracts, or as a nexus for contracts. Regulatory partitioning also helps show how incomplete this picture is. Certainly the state is missing here, and even though regulatory partitioning also applies in private law or contract relations, it applies critically vis-a-vis the state. And it's very important, therefore, to note that one real world function of the corporation is to serve as a nexus for regulation, including state regulation, in addition to its well-known role as a nexus of or for contracts. So how does regulatory partitioning or veil peaking operate? So regulatory partitioning with respect to minority shareholders is essential to the operation of a large firm with multiple shareholders. This is Alice and Apple's example. It would be very hard to have Apple operate if its legal status were to be affected by the purchase of shares by any given shareholder. Therefore, veil peaking as an exception to regulatory partitioning is either categorical, so because there are shareholders in general that have certain rights, then you have the idea that corporations in general have certain rights. This is what I term categorical veil peaking, or it hinges on the existence of corporate control. Corporate control, as any corporate lawyer knows, is a concept that is very difficult to regulate ex ante. You give me a definition of corporate control in a statute, I'll find a way to control this corporation while satisfying, beating your definition. So it's usually subject to ex post adjudication, but it's very costly. You can proceed this way, but it's costly to do so. So usually we'll have veil peaking when the matter at hand is not routine and really worth the candle. So here I have what I believe are the main trade-offs affecting regulatory partitioning, which I claim are distinct from the trade-offs, partly distinct from the trade-offs affecting asset partitioning. I have those trade-offs at the end of the presentation. I can talk more about the trade-offs affecting asset partitioning, but because they are already presented by the literature, I won't go into detail now. One benefit of regulatory partitioning, it's very easy to adjudicate. In this way, it decreases regulatory costs. It's a bright line rule, meaning corporations are separate from their shareholders. So you have crystal rather than mud. Another important benefit, and it's in red here because this benefit is shared with asset partitioning, is that it promotes shared transferability, liquidity, and the market for corporate control because it allows firms to be valued or priced independently of shareholder identity. Right? If you have veil peaking, then the value of the firm will depend on the identity of the shareholder, and that is avoided with regulatory partitioning. It's also a benefit that you have with limited liability, that the credit worthiness of the shareholder will not affect the value of the firm. So those are important benefits of regulatory partitioning. However, regulatory partitioning also has costs, and the key cost here is that it may compromise regulatory effectiveness, because it becomes very, if you uphold regulatory partitioning too strictly, it becomes very easy to form corporations for purposes of regulatory arbitrage. So you have veil peaking cases or regulatory departitioning cases in so many areas of law, and here I'll give you some flavor of the controversies that are described in the paper. So antitrust. Does a parent company's agreement with a wholly owned subsidiary satisfy the requirement of a plurality of actors under the Sherman Act? The Supreme Court says no. For purposes of antitrust laws, they count as one. So there's no plurality. Contract law, does a non-compete covenant apply to a corporation that's wholly owned by the restricted contract party? In many cases, courts have said yes. In corporate law, does the requirement of shareholder vote for a sale of substantially all of a company's assets apply if the sale in question was conducted by a wholly owned subsidiary? Currently, the answer under Delaware corporate law is yes, it does. Should the land owned through different corporations under common control be aggregated to determine economic impact for purposes of a regulatory taking? In the realm of jurisdiction, can a subsidiary be sued under jurisdictional grounds applicable to its parent? In tax law, there are many examples, but one of them is, does the creation of a wholly owned subsidiary serve a relevant business purpose beyond tax savings so that it should be upheld? In international law, can Belgium seek diplomatic protection for a corporation incorporated in Canada, but whose shares are held by Belgian citizens? In international investment law, those are all real cases. I mean, can a Ukraine incorporated firm that is 99% owned by Lithuanians sue Lithuania under a bilateral investment treaty between Lithuania and Ukraine? In constitutional law, those are very popular in the U.S. Should corporations have free speech rights as vehicles for the exercise of free speech rights by shareholders? And even, can citizens raise First Amendment claims against a government-controlled company such as Amtrak? Statutory interpretation. Can Hobby Lobby assert religious rights under the Religious Freedom Restoration Act? Does a homestead exemption apply to a resident that is owned by the corporation, controlled by the resident? So these are some examples of veil peaking cases. One important thing to recognize is that veil piercing and veil peaking, they run in opposite directions. So usually veil piercing, you have liabilities of the corporation attributed to shareholders. There's a directional difference in veil peaking, in which you usually have rights or characteristics of shareholders imputed or attributed to the corporation. Also, one interesting distinction here is that unlike veil piercing, veil peaking generally has no ideological or normative bias. Veil piercing is always anti-shareholder, but veil peaking can work in ways that are beneficial or detrimental to the shareholders, depending on whether you impute legal rights or legal duties or favorable or unfavorable legal characteristics of shareholders to the corporation. Oops. Okay. I also offer in the paper a taxonomy of veil peaking. So you can have explicit veil peaking by lawmakers. This is when the statute in question or the contract in question spells out how legal persons will be treated. Or you can have judicial veil peaking as gap filling. So I claim here that most of the veil peaking controversies that we actually see take place because the relevant legal document, be it the Constitution, a statute, a contract, a treaty, does not specify how corporations are to be treated. You can have shareholder-friendly or shareholder-unfriendly veil peaking, as I mentioned before. And you can have untailored or categorical veil peaking. This is the type of veil peaking that the U.S. Supreme Court resorted to in Citizens United without taking into account the precise characteristics or ownership structure of the corporation in question. Or you can have tailored veil peaking, which is when courts do take into account the precise characteristics of the corporation and shareholders in a given case. And of course, one of the criticisms, say, against Citizens United, many scholars believe that the court should have embraced a tailored as opposed to a categorical approach to veil peaking as it did. So I hope by now you think this makes sense, but is that novel? Actually, there is a very long history of conflation between veil piercing and veil peaking, dating back to the seminal article by Maurice Wormser that coined the term veil piercing. So I went back to that article and I categorized the cases that he discusses in the article, and about half the cases are what I call veil piercing cases, meaning exceptions to asset partitioning, and about half the cases he talks about are exceptions to regulatory partitioning. Up to this day, there is such conflation. When the case of Hobby Lobby was decided, an amicus brief of 45 law professors, I don't know if they were Hastings professors who sent this brief or not, I didn't double check. So those are criminal and corporate law professors, and the argument was that Hobby Lobby, the claim Hobby Lobby was a veil piercing claim that tried to ignore corporate separateness and therefore should be subject to veil piercing criteria, which are very narrow and strict. They require fraud or commingling of assets. There was no fraud, no commingling of assets. So therefore, you should not attribute religious rights of shareholders to the Hobby Lobby corporation. I believe that that type of reasoning is a mistake. I believe Hobby Lobby is a case of statutory interpretation. Commingling of assets should not matter to the resolution of this case. Courts, it's interesting here because one way to interpret this project is as a form of restatement. Courts, because see, the Supreme Court in Hobby Lobby, or even earlier on, the famous case of the UK House of Lords in Daimler, which was the war era case in which the German nationality of shareholders and managers was attributed to Daimler Corporation for the purpose of wartime restrictions. They didn't think those were veil-piercing cases. They decided the cases based on different grounds, and I think they did the right thing by doing so, even though you might discuss the specific result in any given case. So courts have, in part, had a correct intuition about this distinction, although many courts also, I believe, incorrectly apply veil-piercing criteria to veil-picking controversies. So this is one example that I have from the U.S. Supreme Court, and the question here was whether the jurisdictional and immunity rules of the Foreign Sovereign Immunities Act apply to indirect subsidiaries of foreign governments. It was clear from the statute that they apply to direct subsidiaries, but the question is whether they apply to indirect subsidiaries. And then the Supreme Court said the doctrine of veil piercing, again, is requires fraud or other exceptional circumstances, which will be determined on a case-by-case basis, and there is no authority that as a categorical matter, the court could treat all subsidiaries to be deemed the same as a parent corporation. But as we saw before, the Supreme Court does that precisely in the context, say, of antitrust law, treating subsidiaries as the same as the parent corporation. So it says here, this is a broad phenomenon, this veil-peaking idea. However, it has had no name before, and therefore the court has been incapable of discerning its different ways of treating corporate persons across various areas of law. I'd like to suggest here that judicial veil-peaking operate as gap filling, and therefore those cases should be resolved based on the general tenets of constitutional or statutory or contractual interpretation or construction, with special importance being given to the purpose of the regulation in question, and that the restrictive criteria required for veil piercing, such as fraud of commingling of assets, should not apply to veil peaking cases. And so I'm about to conclude. I hope I didn't take too much of the time, so I guess not. So the corporation also serves as a nexus for regulation, in addition to its role as a nexus for contracts. The boundaries of regulatory petitioning vary across legal fields and legal rules, and they are not necessarily the same as the boundaries of asset petitioning. And veil peaking and veil piercing cases are analytically and functionally distinct and should therefore be decided according to different criteria. So thanks again, and I look forward to your questions and comments.
Okay, so I will open it up for questions. Well, let's see. I don't see any hands up. Oh, there we go. Rule, go ahead.
So that was really great and interesting, and I really hadn't thought about it before in the way you laid it out. And I was wondering if maybe you could elaborate a little bit about what I think is a relevant distinction between what you might call statutory veil peaking and constitutional veil peaking. And I guess the reason why it seems, and again, I should phrase this as a question, is that relevant? Because it seems to me in instances of statutory regulation, there's some sort of explicit intentionalism in trying to regulate the corporation. The corporation is a nexus for regulation, and perhaps even instructions. While constitutional doctrines are so much more amorphous that it doesn't seem, I could see how it doesn't lay out the same criteria that might help a court decide when veil peaking is appropriate or not, or in what I think is particularly fascinating, this idea about whether veil peaking should be categorical or specific. Does that make sense as a question?
I think you're muted.
I'm unmuted now. So the question is whether it makes sense to treat differently constitutional cases of veil peaking from statutory cases of veil peaking. One thing is clear, right, that there is a long tradition of U.S. constitutional law cases dealing with veil peaking. Actually, one of the works that helped inspire this article is the book by Adam Winkler, We the Corporations, and he goes through the various cases in U.S. history. He calls them veil piercing cases. And therefore, and as part of, okay, so there was this book, I read the book, I liked the book a lot. I was really intrigued, because in Brazil, veil piercing to make shareholders liable is very prevalent. But courts are not too eager to attribute shareholder rights to corporations. So I was very intrigued about this distinction. Also, in response to Adam Winkler's book, Josh Macy, a young scholar, he's now at Chicago, he wrote a book review saying, oh, what the court is doing in Citizens United is outrageous, because it's an approach that has no parallel in other areas of law. And that in turn inspired Jonathan Macy, the father, to the senior, to write an article with Leo Strine launching a corporate law critique of Citizens United. So all of that is to say that the constitutional part of this holds dearly in the intellectual history of this project. Number one, okay, so I think it's not clearly the cases are not about shareholder liability, right? So the Macy's are right about that. They're not about shareholder liability. But they're wrong in suggesting that this type of exception to corporate separateness is rare. It's not rare at all. It's the opposite. It's quite pervasive. And in fact, I wrote one day to Adam Winkler sending the paper, and he replied 5 minutes later saying, oh, I should have said veil peeking rather than veil piercing. So the phenomenon is there. And the reason I think that I do treat it as gap filling is that I think one of the problems is that the US Constitution, being very old, even though some more recent constitutions are also silent, right, about how precisely to treat corporations with respect to any given right, but the US Constitution is old and it is silent. So there are some reform proponents that actually want to amend the Constitution to make clear that free speech rights not apply to corporations, but only to natural persons. But the Constitution itself is silent. So what are courts to make of that? And clearly, courts have attributed some rights of individuals to corporations, but not others. And some people believe that is incredibly unsatisfactory or incoherent, but I think it's actually the best that the court can do, given that the Constitution is silent on the matter. So I don't know. My sense is that many people actually believe that Hobby Lobby and Citizens United are very similar cases, even though one of them is a statutory case and the other one is a constitutional law case. So I do believe there is a gap in the U.S. Constitution, and if there were to be a constitutional amendment making clear which rights apply to corporations or not, then you would no longer see those types of veil-peeking cases. And of course, nothing in the paper is to suggest that Hobby Lobby or Citizens United was correctly or incorrectly decided as a matter of constitutional law. But I do think that either approach is consistent from the perspective of corporate law, which is amenable to either approach, given that veil peeking actually is not rare, but is quite pervasive, as it probably needs to be.
John, you have a question?
Yeah, can you hear me? Okay.
Yes.
I thought this was a fantastic, okay, great. I thought this was a really fantastic project, and I was curious to what, it seems like both is happening, or both apply. How much you thought that this was adding conceptual clarity, this division between veil peeking and veil piercing, to what courts are already doing, and how much you think that it is going to change what courts do based on courts' confusion over these two principles. In other words, I think both are happening, but how much do you think courts are adopting a more confused view and reaching the wrong results, if that makes sense?
Yeah, so that is a great question, and And I'm not entirely sure, right? So I'm not entirely sure about if this project is mostly a restatement, making sense of what is there with some wrong cases decided on the margins, or whether most cases would actually be decided differently. So one example of what case that would be potentially be decided differently is the case about the jurisdictional case about how to treat indirect subsidiaries of state-owned enterprises. I think there is actually very little ground to treat an indirect subsidiary differently from a direct subsidiary beyond the court's idea that that is veil piercing, and that's something very odd and that it seldom does. So I think that's one case that probably could have been decided differently if the court had realized that it does that with respect to free speech, in antitrust, and so on. But I do think this conceptual clarity is important. So another example is the example of the Ukrainian-Lithuania bilateral investment treaty. It's very odd to allow a corporation, which is almost wholly owned by nationals, to sue its own country under a bilateral investment treaty. And of course, you can have the cynical or political economy view that arbitrators just want to increase the number of arbitration lawsuits, and that's why they decided that way, in which case conceptual clarity wouldn't add much. But I think there's also a sense that veil piercing is so wrong, it's so odd, it requires fraud, so there's no grounds for you to do it otherwise. So I do think that there's some potential here. And I would like to add that I think there is, there's in corporate law, there has been something going on which I find a bit strange and troubling, which is the attachment of progressive objectives to a given. Have I frozen? Can you hear me? Have I frozen?
We can hear you.
Okay. Which is the attachment of a progressive agenda to a certain abstract conception of the corporation. So this is quite common those days. So people just say, oh, I hate Citizens United, and the problem with Citizens United is that it doesn't recognize that the separation is a separate person, as if the world will necessarily be a better place once corporations are recognized as separate persons. I think that's very dangerous if corporations are always recognized as separate persons, because that incredibly augments the potential for regulatory arbitrage in ways that are quite welfare decreasing. So I do think that this component is an important part of the project, as well as the reconceptualization of the corporation as a nexus for regulation. Because there is a strong normative view associated with the nexus of contracts conception, which is that the corporation is a private law matter that does not affect third parties. So there is a laissez-faire connotation associated with that view that was very clear from the seminal article of Jensen and Macklin that gave rise to the nexus of contract conception. They tried to use the nexus of contracts conception to defeat any notion of corporate social responsibility. At any case, I think this is the wrong way to view corporations, because clearly regulatory partitioning tends to affect the relationship between corporations and states and allow corporations to choose their legal regimes to the detriment potentially of third parties. So I think those moves are quite important for me. So in that sense, I think it might be there. I mean, I think I'm describing the world as it exists today, but I think there's something important in shaping the way people view those things going forward.
Thank you.
Mariana, I'm gonna jump into the queue with a question of my own, and so I guess my question, in a nutshell, is: are there any sort of canons of interpretation that you could see emerging? Because it strikes me that this really is mostly about what the court should do in this gap-filling role when you don't have a clear statute telling you the answer, right? So if it's CERCLA and it tells you exactly when shareholders or directors are personally liable for things, that's kind of one matter. You just sort of read the statute, and I suppose there'll be some uncertainties, but that seems clear enough. But the really hard cases are ones that you're pointing out. And it would just seem to me that in a perfect world, we would have some patterns of what either courts should do or are doing. And so it might be that we should see more veil peaking if the statute is concerning a social matter rather than an economic matter, or we should see more veil peaking if it's constitutionally based rather than statutorily based, or if the regulation is sort of a pure sort of status categorization versus really getting at some conduct that at the end of the day individual people engaged in. I mean, there's all these differences in the examples that you're citing. And from that, is there any sort of interpretive direction? Like, when should we see more of this, and when shouldn't we?
I see what you're pushing for, but I'm reluctant to agree. Okay, so I'm reluctant to agree. So let's use, I think with your example, maybe we should have more of it in statutes and less of it in the Constitution. I think it's very hard to defend this position. Even, say, scholars who hate Citizens United would agree that corporations should have property rights, because they are quite necessary for corporations to subsist without being subject to undue expropriation. So I think it's hard. So I think that's something hard to do. Then you could say, well, I believe free speech rights are different from property rights, and therefore they should be treated differently. That I completely agree. But see, that's what I have in mind when I say, well, the purpose of the field in question or the rule in question, not a distinction based on the type of document that you have. So I think it really depends on on the costs and benefits of any given case. To give you one example, I mean, you were asking me before, what do you teach? And I told you, oh, I teach corporations, I teach contracts. And some people sometimes push me this question. Well, what about in a contract? Should you have a presumption of no veil peaking in a contract? I think it depends, Sometimes it's so one textbook example is to say that if I have a non-compete with you and the non-compete is silent, the Mariana Inc. that I set up will not be able to compete with you. So many courts have resorted to this type of gap filling. And I think rightfully so. That does not mean that if we are sophisticated corporation A and B, and we did not choose to cover affiliates, they are necessarily covered, right? So I think you don't have a one-size-fits-all solution to contract law either. I think you have to look at the particular contract and what is the most reasonable way to interpret this particular contract. So it might be that if two sophisticated corporations in a large transaction cover affiliates for purposes of similar clauses, but not with respect to others, then you would uphold regulatory petitioning. But I think it's not possible to have such broad categories of peaking or no peaking. I know how tempting this is, but I don't think that's how the law currently works, and I don't think that's how the law should work. Instead, I think we should recognize and embrace the on and off character of regulatory petitioning. I think probably our legal system will operate in a more reasonable fashion overall if we recognize that perhaps, and I'm working with that idea right now, corporate separateness is not an absolute rule, but perhaps it's a prima facie idea, It's and contrary considerations can lead to different treatment, and that is fine. Many ideas are like that. Many rights are subject to exceptions, so is regulatory petitioning. And I definitely don't think that the type of document could do the work, unfortunately, or the other category. I mean, I know you suggested a bunch of other categories, but I think they're also likely to fail for similar reasons in which that they would be dysfunctional.
Okay, got it. Thank you. Heather.
Terrific. Thank you so much, Mariana, for this really interesting project. So I'm a tax person focused on business tax, so I kind of read your paper through the lens of the business tax world. And it raised kind of two questions for me. One is, when I think about corporate tax in the U.S., the question is really generally about the identity between owners and entities, and a lot of the rules do not distinguish between directionally in the way that you do. And so the way you're separating it seems really interesting to me, because a lot of our rules in tax are like, okay, well, we're going to talk about attribution of ownership, and it goes in the same rules, like up and down, from corporations to shareholders, from shareholders to corporation. And then that becomes relevant for the tax treatment of redemptions and the tax treatment of kind of sales to related parties and the tax treatment of kind of expenses paid among related parties and whether they can be deducted. And the rules kind of work both ways, and the tax laws are generally not distinguishing between what you're calling veil piercing and veil peaking, or I guess like the other direction. And so I guess, so the first question is kind of why do you think that some regulatory regimes kind of have very different rules from veil peaking and veil piercing purposes, and other regimes kind of have kind of really kind of unified rules in both directions? Actually, I'm just going to leave you with the one question for now, and I'll come back later with the second question if there's time.
Yeah. Okay, so one way to think about it is that tax law often uses an enterprise conception. And in this enterprise conception, all you have is the enterprise, and you're not worried so much with the types of, the direction of the boundaries that I'm talking about. And I think the reason that is for tax, for instance, is that very often you're talking about, especially in the US, about wholly owned subsidiaries. The US has rules that discourage some other types, pyramidal structures. So in the end, that might not make so much of a difference, as opposed to talking about individual shareholders. And then I think the type of direction you go might make more of a difference. But I would say, well, I gathered that you said veil peaking is pervasive in tax.
In a lot of situations, but in some situations, no.
Exactly, right? Because if it were completely widespread, then you could not use corporations for tax arbitrage, which you do very often. So you have both approaches in tax, actually. And I would say that actually, in terms of talking about the intellectual history of this paper, one of the controversies that was really influential in shaping my thought was a tax law controversy that is cited by Oliver Hart in his Nobel Prize speech. He actually cites a case in which he was an expert, for the U.S. government. And the question was the question that I said in the beginning: is this wholly owned subsidiary, did it have a relevant business purpose? And Hart, the economist, said, oh no, because it's wholly controlled. And in my theory of the firm, what matters is control. So a wholly owned subsidiary does not have any relevant business purpose. And then he essentially advocated for veil peaking, and he got it. I think actually those cases prevail. So tax go both ways, and I think answering the question, I think the reason why you don't generally see the distinction is because you're talking about wholly owned subs. If you're going to talk about individual shareholders, then I think the distinction is more likely to matter. You are more likely to attribute, say, the nationality of majority shareholders to the corporation, but not the other way around, right? So not from the corporation to shareholders. But in the corporate group context, those things very often get muddled under an enterprise approach, which disregards legal entity boundaries in favor of this economic approach.
Thank you.
Great. So next I'm going to let Jody, who lacks hand-raising capabilities due to her co-host status, give her an opportunity to jump in live.
Great, thanks, Abe. So my question actually follows on a little to yours, and I'm really sympathetic to Mariana's response to your question that it's hard to come up with some sort of a bright line rule here, and really, hard and fast distinctions, that we need more fine-grained analysis on a case-by-case basis. But I guess what that makes me wonder is whether that undercuts the justifications for regulatory partitioning generally. Once we start going down this road and recognizing this is pervasive, and we can't really tell when it's going to be, when we're going to peak and when we're not going to peak. But for doing this really fine-grained analysis, case by case, it just strikes me that I don't take this to be your project, but it does strike me that it becomes harder to justify regulatory partitioning. So I guess I wonder if you've thought about that problem at all. And then I think a related thing that a couple of the comments have raised for me is whether there's some sort of like hydraulic relationship between asset partitioning and regulatory partitioning. Have you thought about the interaction of those two, such that maybe if you have more of one, you have less of the other? Is there some dependent relationship there?
Okay, great. Great question. So one way, okay, so about the justification for regulatory partitioning. Look, I think it is critical with respect to minority shareholders. I think it's one of the, just as entity shielding, this was a kind of a key contribution of Harry Hansman and Rainier Krachman when they coined the term asset partitioning. Is that it's not only about limited liability, it's about how creditors of shareholders cannot attach the corporation's assets. That's very critical, because if they could, you cannot have large-scale enterprise with multiple shareholders, especially because unlike limited liability, it's very hard to contract for entity shielding. Therefore, they say, and I think this is a very important insight, therefore, it's not true that a corporation is only contracts, because it requires entity shielding, which is a form of asset partitioning, that only the law can give. So there are certain legal preconditions to firms as we know them. And I think regulatory partitioning with respect to minority shareholders is one of the legal preconditions of firms as we know them, a legal system that did not recognize this type of regulatory partitioning would be unable to recognize a large-scale firms. So I think that's conceptually important. See, in the history of corporations, that could maybe be taken for granted if you have firms with dispersed ownership. So basically, if you have firms with dispersed ownership, you tend to have less veil peaking. You might still have it in some cases. You have a widely held firm that is controlled by Germans, war against Germany, and the managers are German. You might still have veil peaking, but you wouldn't have the other forms of veil peaking with respect to controlling shareholders, which is what you have in so many cases. And it is also true that in the history of corporations, some of the early corporations were non-profit corporations. They had no shareholders. And in the history of corporations, some of the early corporations had dispersed shareholders. They didn't have one person whose will determine the corporation's will, which we have today in most of the world, actually, and increasingly in the US as well. And I guess one way to think about it is whether you absolutely need regulatory partitioning with respect to controlling shareholders. And I think the answer is sometimes you don't, actually. So you might want to think about controlled corporations differently from widely held corporations. There's really someone, you have Facebook and you have Mark Zuckerberg, some corporations, controlled corporations might be treated differently. I do think that there are complementarities between asset and regulatory partition. I wanted to insist that if you look at the law, so Heather will say that for many cases, actually tax treats corporations in the corporate group as the same in ways that a commercial court will not treat them as the same. So there are differences in the real world between the boundaries of asset and regulatory partitioning. But they do have this complementarity of allowing firms to be valued and traded irrespective of shareholder identity and facilitating the market for corporate control, turning firms into anonymous entities. I like that. It's the word for corporations in French-speaking countries, and also in Portuguese, corporations are called anonymous companies. Regulatory partitioning makes them anonymous and therefore more easily tradable. So it's complementary with asset partitioning, but I think the benefits of transferability in controlling agency costs and allowing for perhaps a more efficient form of industrial organization, sometimes they will have to cede to countervailing public policy considerations. So I think it's important to recognize a role for regulatory partitioning, because if you are going to do veil peaking based on control, which is what I suggest, it's very hard to do. You have those costly inquiries, the type of inquiries that you have, say, in an antitrust controversy or in a corporate law controversy. That's fine when those inquiries are rare and the stakes are high, but you probably won't do it in fairly routine basis, which my sense is was also what tax law does for some more routine matters. It treats corporations as separate, but for some other matters, it then scrutinizes the relationship. So I think it's important to recognize the importance of regulatory partitioning and also its limits with the limitations that I have in this framework, which is also, although the paper covers many areas of law, it's also humble in not saying I have the answer for any single for any given controversy in all of those areas. Acknowledging that the claim is still useful. Probably the amicus brief for Hobby Lobby should have been written differently, I believe, without focusing on commingling our assets or fraud. I think those are not the correct test for the cases, and many cases, unfortunately, still follow this traditional approach.
Do we have other people who have just been shy? Okay, Heather, go ahead.
So I'm happy to defer to other people who have questions. Okay.
Go for it, Heather.
All right. So now, Mariana, this might be outside of your scope, and if it is, that's fine. But the conversation that we've been having about veil piercing and veil peaking in corporations, we have in tax for corporations, but we have the same conversation for partnerships, right? I spend a lot of time in partnership tax, perhaps to the chagrin of my students, talking about when do we use the aggregate theory of partnership to impose tax, when do we use the entity theory of partnerships to impose tax, when do we use a hybrid, what does the hybrid look like? And I was just wondering how, and I guess to what extent, do the issues that you're raising here in the corporate context, do they resonate? Are they relevant in the context of non-corporate entities like LLCs or limited partnerships and things like that?
Oh, wonderful. So thanks, Heather. So you have the right intuition about my next steps in this project. So the paper that you read is still a draft. It's forthcoming in the University of Pennsylvania Law Review. The first draft is due in a couple of weeks. But at the same time, I've just written a very short book chapter for a handbook on corporate purpose and personhood on I don't even remember the name, but it's something about the key role of regulatory partitioning in organizational law. And the point I make is that you have the very same issue. Actually, if you think about the whole entity versus aggregate conception of partnerships, it's primarily about regulatory partitioning. It's not about asset partitioning. You know, the treatment of partnerships with respect to asset partitioning is primarily about regulatory partitioning. Tax is one component, but there are various other components which I do talk about in the paper. So I think so I think it goes this way. Probably the corporation has stronger regulatory partitioning than partnerships and those hybrids, but you also have some of those controversies. And actually go a step further. If you think about organizations from a functional perspective, you also have natural persons, right? So under standard conception, a natural person is also a nexus for imputation. And historically, well, you certainly have the idea about husband and wife. Do they merge and the personality of the wife disappears? Partly, actually, it was on and off, you know, for some purposes. The wife lacked legal personality, but for others, it could still be, a wife could still commit adultery. So for those purposes, she had her own legal personality. But even to this day, say in corporate law with respect to conflict of interest analysis, if my husband has some business, that might be imputed to me for purpose of conflict of interest analysis as my sisters or my daughters. So there's this on and off treatment of regulatory partitioning. So generally, legal natural persons are deemed to be separate, but for some purposes, you're not deemed to be separate from your spouse or your parents or your siblings and so on and so forth. So actually, I do think this regulatory partition is an essential attribute of organizational law, broadly understood, of legal entities, broadly understood, just like asset partitioning is. And I think it does help illuminate a lot about the kind of hybrid entities and partnerships as well. So thank you for the comments.
Terrific. Thanks a lot.
Okay, well, it looks like we're to the end of our time. So how about one of those funny looking Zoom claps for, oh, well done. We're getting the hang of this. So thank you very much. It was a wonderful presentation.
Thanks so much. Very stimulating. Such a privilege to talk to you guys.
Thanks, everyone. Thanks so much, Mariana.